Good morning and welcome to today's session, Legal Considerations for Authors and Illustrators, Part 1. So if you are watching this and you registered for the original date, you're probably aware that our presenter, Adrienne Haynes of Seed Law, was ill, so we had to postpone. So today's sessions are taking place in the same day, with Part 1 now and Part 2 taking place later today. Because Adrienne was sick, she accidentally double booked herself for this time. So she went ahead and recorded the content that she was planning to present today. If people do end up joining, she may be available at the tail end for any Q&A. So I am going to go ahead and pull up this video and we will get started.
Welcome to Legal Considerations for Authors and Illustrators, Part 1. My name is Dr. Adrienne B. Haynes, and I am the managing partner of Seed Law. I'm excited to get into this two-part series with you. Thank you to the Kansas City Public Library for hosting and sponsoring this series designed to give an overview of some of the most frequent legal questions that we receive from our author and illustrator clients about the business of being an author, protecting and managing one's intellectual property and using the intellectual property of others, navigating contracts and relationships, and a nod towards estate planning. As a way of background, I am an entrepreneur who wondered where the lawyers were. So in 2010, I came here to Kansas City to attend the University of Missouri, Kansas City School of Law. And while I was running businesses, I was also in law school. So today, Seed Law is 7 years old and was founded in 2015. And we've been fortunate to represent entrepreneurs and individuals in a variety of different industries and over the life cycles of their businesses. And we really have a focus on educating our clients and developing long-term relationships that contribute to sustainable business practices. I'm also here sharing some experience that I have learned in this first year of owning GWL Publishing, which is Generational Wealth and Legacy Publishing, founded to provide business support services and publishing support for thought leaders and creatives. There is about 90 minutes of instruction that we'll be able to have here together, and there's no way we can cover every single legal consideration that an author or an illustrator may face in the course of their business, but we're going to host a good overview of some of the most important kind of high-level questions that we think that authors and illustrators should be mindful of. So for part 1, we'll discuss the business of being an author, separating this writing passion from a hobby into a business. We'll also talk about establishing a business entity and navigating intellectual property, specifically copyright and trademark. For part 2, we'll move from manuscript to published. We'll review some contract law considerations and a short nod towards estate planning considerations for authors as well. Although this session is pre-recorded, all Seed Law workshops and Kansas City Public Library workshops are designed to be interactive, and we want to hear from you. So drop a comment in the chat to please introduce yourself. If you have any questions, please let me or the moderator know. Share your experience with the topics that we're discussing, and we'll get that incorporated as well. Before we jump in and talk legal, we always like to introduce a case study business owner. So I'm going to introduce you here to Dr. Ryan. I'm going to share with you her story, and I'd ask you to consider what legal issues that you hear during this review. Dr. Ryan is a teacher and basketball coach that has been making a positive impact in her community for the last 20 years. Her teaching and coaching methods have been widely acclaimed as transformational, both to student grades and athletic ability, and people have been asking her to write a book for years. As she looks ahead to retirement, she's decided that writing may be a good way to keep working at her own pace and supplement her income. Because she's about 5 years from retirement, she's decided to start writing this summer. She compiled a memoir with some coaching lessons, but was having a hard time getting excited about the material. Her favorite genres to read are science fiction and genealogical history, and this weekend, she decides to go to a sci-fi writing workshop course at the local library. After the workshop, she outlined a 4-part sci-fi series to begin with and decided to write from a pen name to keep the writing separate from her teaching and coaching work for now. She chooses the name Ellen Uhura after Lieutenant Nyota Uhura in the original Star Trek series. During the summer, she's inspired and her writing is going well. She's starting to make some financial investments in her work and decides to share a first draft of that first book of the series for feedback from family and friends. She printed 10 copies at home and distributed them with really no instructions except for some constructive criticism. A few weeks later, she gets a call from a gentleman named Arthur who says he's a literary agent and that he happened upon a hard copy and likes the direction of her series. He requests a meeting with her and shared grand experiences of making others wealthy from writing. He'd like to represent her and sends over a detailed contract for signature. Confused, she does agree to the meeting, but chooses not to sign the agreement. During the meeting, Arthur pulls out a manuscript, her manuscript, reformatted into a spiral-bound packet with cover art, her full name, Dr. Ryan, instead of her pen name, and a short summary that she did not write on the back. She was planning to write the full series next summer and work with a fellow teacher on art and illustrations. It all seems to be moving a bit fast for her, but she does want to keep her options open and make a viable plan after retirement. Let's take a moment and think about the legal issues that you hear. A few that came up to me in this scenario is that Dr. Ryan is planning to write long-term. She wants this to be supplemental to her income and retirement. And so because it's a long-term plan for her, she may consider formalizing an entity. If she was just thinking about doing one genealogical history book on her own family, perhaps she, may not need a business entity at that point, but she's already started to a 4-part series. Another legal issue that you may hear is the use of Uhura from Star Trek. In this case, upon really quick first review, that is okay for a pen name. CBS Studios does have a live trademark on on Uhura for toys, namely posable figures, dolls, accessories, and decorative plates. But as a pen name, Ellen Uhura, people may not put that together as a nod towards Star Trek, which means it doesn't necessarily infringe on their trademark or disparage it. Another legal issue that came up is that she shared advanced copies to a close circle without specific terms, and somehow a copy was shared. She doesn't have any recourse because she didn't make clear what the terms were for hosting that advanced copy and confidentiality. Another legal issue that's common for authors and illustrators to remember is that any relationships with third parties, whether it be a literary agent, a self-publishing platform, or a narrator, should be reviewed by counsel in advance and and to ensure that the contract terms are consistent with what the author or illustrator wants to do long-term with the work. There were also some unauthorized amendments to her work, including the spiral-bound packet, the cover art, the name use, and the blurb. She does want to work with an illustrator long-term, so she could put a contract in advance for that now. And there should be a legal review of how this impacts her retirement, pension, and estate plan long-term. As we can hear from that case study, the business of being an author is much more than just putting thought to paper. As thought leaders and creatives, we know that being well-researched can help you develop a solid plan for your writing and consider the process in full. I encourage you to start with the end in mind. You can start any creative business with a firm foundation, and to me that means sustainable business practices that invite us to minimize risk and liability while pursuing the passion, that invite us to create systems and processes that are efficient. Perhaps for Dr. Ryan, an efficient way for her to produce her series, review it, get it edited, formatted, and into her final format that she'd like to share it. And of course, to mind the money. Because once you complete your book, you'll want to sell it, and you'll need to think about both the investment that it'll take to get the book to fruition, as well as the money that you want to make from the writing as well. Success as an author requires world building, character development, multiple drafts, other experts, marketing, sales, bookkeeping, and again, that ongoing engagement. So it's important to consider what part, as an author or illustrator, what part of that work you enjoy and which parts you may want to share or delegate with others. The second note about the business of being an author is to set up good habits and processes in the beginning. From a writing schedule to your expenses to your marketing outreach, it's important when you think about the business of being an author that you're working on the business and not just in it with the writing. You'll also want to document your relationships. You may have co-writers, ghostwriters, editors, illustrators, narrators, agents, etc. Keeping those expectations and legal rights clear allows you to focus on the writing and know what exactly you're promising with each edition. Dr. Ryan, as we know, needed contract support with the pre-distribution list and for the potential relationship with Arthur and her illustrator. We'll get more into contracts in part 2. Lastly, my point on considerations for the business of being an author is to encourage you to actually set up a business entity. If you know that your writing passion is much more than a hobby and you want it to be something that you're working on long term, consider establishing a business entity with the Missouri Secretary of State. For the scope of our choice of entity conversation today, we're going to discuss really 2 types of business entities, which are the most common for authors and illustrators: sole proprietorships and limited liability companies. There are other types of business entities that may be applicable to you, that may work better for your plan as an author or an illustrator, or for your own personal tax considerations. A gentle reminder that even these early considerations are legal decisions and entities are created by state statute. So you should talk to a licensed attorney about how starting a business impacts your overall and your tax liability. Knowing these definitions and doing this overview is helpful in doing that preliminary research, but qualified counsel here is key. If you only intend, again, to do one book or share something just with a limited circle like your family and friends, you may not need to establish a formal entity. Under business law considerations, that would be operating as a sole proprietorship, a business in which one person owns all the assets, owes all the liability, and is operating in a personal capacity. So Dr. Ryan writing as, Dr. Ryan, she's not operating under a business, just herself personally. If you want to operate in a sole proprietorship, there's no registration needed with the Secretary of State and no paperwork necessary to get started according to state statutes. Any money made or lost in a sole proprietorship is recorded on one's own personal tax returns. The business lawyer in me would always say that if you're thinking about doing this as a business and not just a hobby or a passion, that you formalize into an entity. And a limited liability company is a filed business in which the members or managers have statutory limited liability protection of a corporation, but the minimal ongoing corporate formalities of a partnership. This business must be registered with the Secretary of State using each state's specific articles of incorporation, and many states will require by state statute some sort of corporate governing documentation. With an LLC, it's called an operating agreement that talks about how business decisions will be made in that company according to the state statutes. So if you don't do an operating agreement and something happens, how the business is managed or operated will be reviewed and according to the defaults in the state statute, but your operating agreement allows you to make some specific kind of customizations about how you want to run your business. I do encourage you, if you have an LLC, that in the state of Missouri, it is required that you have an operating agreement. And I encourage you to make sure that that's customized to the way that you want to do business and the way that an operating agreement talks about tax qualifications. It talks about how you work with others. It talks about how money is managed in the business, and really most importantly, what to do in the case of death or disability of an owner. So you really want to make sure that your operating agreement, again, is custom and specific to you and the way you do business, and not just something that maybe you found online that, says Missouri operating agreement. When you start with a business in mind, when you think about being an author and illustrator, I think it gives you an opportunity to think ahead about who might own any ISBNs that you need or international standard book numbers for your books. It could be the named business for any contracts, and I think it can also assist in leveraging your intellectual property. Again, in this situation in Missouri, an LLC does not expire. So Dr. Ryan could start her business now and use that as a way to develop a business and a brand and kind of a financial history in addition to her pseudonym and the series that she's developing. That was a very brief overview of choice of entity. And again, I do encourage you to use resources that are available to you, such as the library's legal GPS, to prepare for a meeting with an attorney, and then to actually host a conversation with a professional service provider so that you make sure you're on the right track. Okay, let's get into a big topic for our authors and illustrators, which is intellectual property. As an aspiring or existing author or illustrator, understanding how to create, protect, and leverage intellectual property is crucial to maintaining your competitive advantage. IP is a major legal protection for essentially protecting what we call products of the mind. And today, for the scope of this discussion, we're going to discuss two main IP protections: copyrights and trademarks. Just like entity considerations, there are other IP protections that are available beyond the scope of this conversation, but here are the two main that we'll focus on today. So a copyright is a form of protection provided to authors of original works of authorship, including literary, dramatic, musical, artistic, or other intellectual works. The authority for copyrights is the United States Copyright Office, and a trademark is a form of protection for words, phrases, symbols, logos, images, or any combination thereof used in connection with the sale of goods or services to designate the source of its origin. Trademarks are governed by the United States Patent and Trademark Office, And pursuing these protections with either office, I will encourage you and remind you up front that they do take time. They will require financial investment, and any filings may also require revisions. So before we start and before we get into the slides, let's just cover really quickly why one might file. So for either, when you file with either of these authorities, the U.S. Copyright Office and or the U.S. Patent and Trademark Office, it gives a legal presumption of your ownership of the mark or of the work and in your exclusive right to use that nationwide or in connection with those goods and services. It does give a public notice of your claim of ownership for the mark, and it's listed in online databases, which is important. So let's talk about copyrights first. When you think about a copyright notice, here quickly are the elements of a copyright notice. You'll see copyright is used. We see the symbol with the C here, the years of protection, the company, and all rights reserved. So you want to use the symbol, the years, the author name, and an indication that the rights are reserved. Again, copyrights are forms of protection for written works of authorship, including the list here on the left, literary works, musical works, dramatic works, choreographic works, all the way to architectural works. For copyright protection to be applicable, it does have to be tangibly expressed. So a book, an audio CD, a photograph, and it has to be the result of creative, original, and independent authorship. So again, with a copyright, it's about the idea versus the expression of the idea. So a copyright will not cover an idea, procedures, processes, principles, etc. But if it is tangibly expressed, then it can be copywritten. One way I like to think about this is if it can be read, it can be protected. So that goes all the way to software codes. Copyrights are helpful just like owning any other piece of property because they can be sold, assigned, licensed, given away, and bequeathed, which we'll talk about soon. You can license your literary works and artistic works with others while retaining that authorship, and it can be a potential source of revenue. Please note too that you can have several copyrights in the same work. For example, each of these images here on the slide, these are copyrightable works in themselves, separate from the work that it's covering. So Jaws, the movie, and this movie poster are both copyrightable works. Janelle Monáe's Electric Lady album has a pictorial or a graphic copyright in the cover image, as well as the copyright in the album itself. Okay. When you have a copyright, this is governed exclusively by federal law. So this copyright gives you exclusive rights to reproduction, distribution, public performance, public display, adaptation, or any derivative works, and digital audio transmission. The duration of a copyright is the life of the author plus 70 years, or if owned by a business or unpublished, or if the author is not a person, it's 95 years from first publication or 120 years from creation. To get this copyright protection, again, it does have to be original works of authorship, must be fixed in a tangible medium of expression. So print, video, digitally. And once that's done, you can use the copyright symbol immediately, but the work does have to be registered with the United States Copyright Office in order to sue someone for infringing on those rights. Okay. One other thing I'd like to note here is that the timing of a copyright is generally 6 to 9 months, and the grant time can be as little as 2 months once that application process is completed. Again, just as a note for authors and illustrators, under a copyright, what can be protected? Again, you can have multiple different copyrights and multiple different copyright authors or owners, in a work. So protected is the expression of the idea into that story, the drama, the movie, the book, etc. The text, in the book. The font of the book can also be copywritten. Illustrations in that book, any sound recordings for the audio performance, and non-literary elements such as the cover photography, history, jacket notes, etc. All the way down to your blog and your website materials as an author or an illustrator. What's not protected under copyright is the poor man's copyright. So you may have heard people say, I'll just mail it to myself. That's not legally sound. Facts, procedures, processes, systems, methods of operations, etc. Those are not applicable. They don't count as something that can be copywritten. Book titles, character names, ideas, themes, plot lines, etc. General characters and settings for the scope of this discussion, those things are not protected under copyright. We're going to talk about those in a minute though. Okay, let's talk about trademarks. So the elements of a trademark notice include the symbols and the years and the author's name. So just as a note on these two symbols here, prior to registration, you can use TM. And once it has been accepted and registered with the U.S. Patent and Trademark Office, you're able to use the registered trademark symbol. A trademark is a word, phrase, symbol, logo, or combination thereof that is used to identify the goods and services, and distinguish them from other providers. This is helpful for creating a brand, preventing others from using your product or service name and causing confusion. It's good for increasing awareness. And you can see here, we have some copies of some logos that are quite popular here in the Kansas City area, words and phrases that have been trademarked here, as well as non-traditional trademarks. The one I like to make a note of is Morgan Freeman, which is trademarked for entertainment services, namely live, televised, and movie appearances by a professional entertainer. Trademark, again, we did talk about the TM versus the federally registered mark. You don't have to be registered, but federal registration gives you benefits beyond just using that mark. It allows you nationwide use with associated goods and services, incontestability after 5 years, some level of customs control, and a basis for foreign filing. The duration of a trademark is 10 years, but it is renewable indefinitely if it's properly maintained. And in order to get trademark protection, you do have to show that you've used the mark in interstate commerce or indicate an intent to use as well. One thing about trademarks to remember too, just actually intellectual property in general, is that when you decide to build a business as an author and illustrator, generally people are developing what we like to call an intellectual property suite. There may be multiple copyrights that you are registering and that you own, and also trademarks that you're owning over time. There are several types of classes, associated goods, as it relates to trademarks. And so I do encourage you to talk to an attorney to identify where your possible protections are, and to ensure that you are managing well the IP of others as well. Generally, for a trademark, it takes about 9 to 12 months processing time if everything goes well. And as a reminder, sometimes you may submit a filing and there's revisions that are necessary with the agents that are assigned. So for a trademark, what's protected? Book titles may be protected if they are unique, distinctive, and not just descriptive. If people know about those kind of book titles, Harry Potter, if it's a part of a broader series, and if it's connected to really a broader business venture. Pen names can also be trademarked. Character names might be trademarked, and logos, other unique aspects. Again, so it could be the word Batman, it can be Batman with the symbol, so any word, phrase, logo, or any combination thereof. Speaking of Batman, here we see Bat Spaceman is saying that it's not copyright infringement because his name is one word and mine is two, and he may be right, although he likely has a trademark claim. All right, so that was a lot of legal discussion. So let's just high level, what are some general tips for protecting your IP as an author or an illustrator? From your business logo to your cover art, you want to make sure to the text of your book or the images that you're developing, you want to make sure that your work is original and legally protected so that it can be legally protected. You want to apply for recognition under state and federal law. We know that you don't have to file, but in order to put people on notice and to be able to pursue your rights and against others for infringing them, you really do want to register under federal law. You want to put infringers on notice by using either the TM, the registered trademark, the copyright symbol, and we're not discussing patents today. But there's also a patent pending notice that you can use if your patent is not yet confirmed. One thing that I encourage authors and illustrators to do is to adopt a limited use policy for using your content. So perhaps you develop a book and then you also have a blog where you're kind of promoting and talking about your book on a regular basis. You can adopt a policy for using that content where they might quote up to 50 words, give credit or attribution, as long as it's non-commercial use, and don't change the meaning of the actual text that you put forth. So there might be ways to encourage people to use your content and your thought leadership without infringing upon your rights. Of course, contract provisions do help outline some of these IP protections, and we'll talk about that a little bit more in part 2. Once you develop a business, whether you recognize it or not, IP is being created. And so I always encourage our authors or illustrators to be mindful of what they're developing and to think about the plan for long-term transfer if and when appropriate. From licensing to bequeathing, it is important to consider. I think, and no matter what business you're in, reviewing your business supply chain and your processes to make sure that IP is being closely monitored and protected is important. So in the example of Dr. Ryan and her business supply chain, even early on for her beta readers, she had IP leak, intellectual property leak, because Arthur, somehow came up with a hard copy of her book. So you want to make sure really at every level, even from your sharing the advanced copies of your manuscript, that you know how that intellectual property is going to be managed. And ultimately, litigation is a possibility too if your intellectual property has been infringed, but there are some steps you can take in advance. You can use cease and desist letters, demand letters as a scare tactic, or to encourage people to partner with you through licensing, or other opportunities to really leverage your brand. Okay. Next, let's just talk briefly about using the IP of others. Okay. So if you're using a brand name, a quote, an image, lyrics, or anything in your work created by someone else, it is very important that you stop to consider if your use would be infringing upon their IP. So let's start with copyrights. Copyrights, again, are protections provided to authors of original works of authorship, literary, dramatic, artistic, musical, and other types of artistic works. So if you're using, let's say, lyrics from someone else, or, okay, well, let's back up. So when you're using the IP of others, consider, does it fall under what can be protected as a copyright? If not, if it's not copyrightable, then there's nothing to worry about. If the copyright has expired, so anything published before 1923, published after 1977, or 70 years after the author's death, that's okay. If it's a work created by the US government, it's not copyrightable and is okay for use. And if a work has been donated to Creative Commons, that's okay to be used as well. If you are using some copyright material and you find that, yes, this does qualify as a copyright, but I do want to use it, there's really two considerations that we would encourage our clients to do. To take a review of the fair use considerations and then also to get permission if needed. So when you're thinking about fair use considerations, there's 4 factors. So Section 107 to 120 of the U.S. Copyright Act allows exceptions to copy and use copyrighted material for really specific purposes, including criticism, comment, news reporting, teaching, scholarship, or research, as long as the public interest is served. So in that review, consider what is the purpose and character of the use, including whether the use is commercial or nonprofit or educational, the nature of the copyrighted work, the amount of work that you'll be using to, the amount of copyrightable work that you'll be using in your work. Shorter is always better. Full chapters is in an educational setting may be appropriate, but in your own book, likely not. And the amount, and then the effect of the use on the potential market or the value of the copyrighted work. When you're thinking about fair use, those are the 4 considerations to take under advisement. And then if you feel like maybe it isn't fair use, get permission if you have to use it. But I always, there's a lot of different ways to write a book. And so we encourage people to be creative there and to make sure, just high level, you don't want people infringing upon your IP. And so use that same consideration when considering using the IP of others. Second, trademarks. So an author colleague of mine asked me the other day if he could use brand names in his book, and the short answer is yes, as long as it steers clear of making a generalization of the brand. So Xeroxing, or Band-Aids, things like that. Those are actual brand name trademarks versus photocopying or bandages. And you want to make sure that the use of the brand name doesn't cause any defamation, tarnishment to the brand in question, confusion among its customer base, or tarnishment, again, defamation or tarnishment to that brand in question. So when you're using the IP of others, again, consider, is this even protected? Does this count as protectable intellectual property of others? If not, there are some exceptions. If so, there are considerations to work through to make sure that your use does not infringe or cause other IP owners to be in their detriment. And then for trademarks, generally brand names can be used as well, as long as the use does not disparage, does not cause defamation or confusion among the clients or tarnishment to that brand. Okay, that was a very high-level overview of the business of being an author, some of those considerations that our author clients come up against when they're first starting their business, and some of the most frequently asked questions that we get around intellectual property as it relates to authors and illustrators. That is part 1 of legal considerations for authors and illustrators, and we'll join you soon for part 2.
All right. Thank you, Yasmin and Fred, for joining. Fred, I know you weren't on this when we started, but Adrienne accidentally double booked herself, so she had to pre-record today's content. So what I wanted to do right now is quickly show you how to access Legal GPS through the Kansas City Public Library catalog. You might remember Adrienne mentioning Legal GPS when she was talking about the different forms of entity that are most common for authors and illustrators, being LLC and sole proprietorship. So Legal GPS is a tool that helps business owners and business aspiring people figure out what entity is best to set up for their business. And right now I am going to share my screen so that you can see exactly how to access it through the digital catalog at the Kansas City Public Library page.
Morning, Hadiza, and thank you.
Good morning. Okay, so you'll be on the Kansas City Public Library homepage at kclibrary.org. And then you're going to go to resources/research and hover over that to then see that all of our resources that are listed in our digital catalog are listed alphabetically. So we're going to go to L for Legal GPS. And if you have used Legal GPS before, there have been a few changes. Legal GPS has now been rolled into a bigger tool called Wayfarer, which once I actually log in, you'll see what it is. So we're on L in the digital catalog. So we're scrolling down to Legal GPS. Then we will click on More Info. And at this point, once we get to the entry in the catalog, we're going to see some instructions for how to actually access Legal GPS. So if you've used Legal GPS before, it has changed. Once you click on Access Legal GPS, it's actually going to take you to a page called Wayfarer, and you're going to need to create an account with Wayfarer. And then log in with a confirmation code that Wayfarer sends you to your email, and then create new credentials to then access. So once you actually have created that Wayfarer account, you will be able to see how it works. Okay, so I've done that already. So I'm just going to go ahead and sign in. And actually, I need to back up. Before we get to this page, this is actually what Wayfarer looks like. So the first time you get to Wayfarer, it's going to look like this. It's going to ask you to pick a path. So depending on what you're using Wayfarer for, if you don't know anything about Legal GPS and you happen to be at Wayfarer, you're probably going to be using Wayfarer for learning how to use a Chromebook, for assistance with looking for a job, or just assistance with digital resources for learning and research. But today, again, we are focused on Legal GPS. So we're going to go all the way to the right-hand side here, and we're going to click on Legal GPS as our path. And so once we do that, we'll be able to access it. So I'm going to stop right there. That's just to show you how to get to Legal GPS since it has changed. Feel free to reach out to me if this is something that you want assistance with. I will be sure to share all of my contact information in a follow-up email after part 1 has been uploaded to YouTube. So just so that everybody knows, whether you're on this live or you're joining later, for everybody who has registered through the Kansas City Public Library website, you will be getting a follow-up email in a few days after parts 1 and part 2. That will provide you with access to the YouTube link, which is just a recording of today's session, as well as a copy of the presentation itself so that you can follow along and have for your own study after watching. And then I will also include my Calendly link that allows you to schedule a one-on-one meeting with me. Right. So without further ado, I don't think Adrienne is going to be able to actually make it for the last 10 minutes because I have not heard from her. She said she may or may not be able to, but Adrienne will be presenting part 2 at 1 o'clock. So if you're able to join, please make sure to join with the Zoom link for that. And we will see you then.
So is this it for the morning?
Yes,
Okay, then 1 o'clock, be back, right?
absolutely.